Good morning and welcome to the second edition of Transitions with Dignity webinars. I'm Carol Phillips. I'm your host and your senior real estate specialist realtor. And I'm also the author of the award-winning book, Transitions with Dignity. Last week, we talked about how to decide when you're ready to move and where you're going to go. And we visited with two different families about that and two different solutions. So we now know there's lots of solutions. And in my book, I talk about boring but necessary documents and how important it is to create an essential document folder. And to that end, today we're going to talk about trusts, wills, and probate and what's in your best interest. So I'd like to introduce my friend Ron Adams, who is a estate planning attorney here in Phoenix and in Salt Lake, I'm assuming. And he's been my friend for a lot of years, and he's done our estate planning and guided us well. And I think he will answer a lot of good questions for you. So good morning, Ron.
Oh, good morning, Carol. It's great to be here. Although I got to take issue with estate planning is boring. It's not boring at all.
Well, I have to agree. It is kind of interesting, but when you're in the grand scheme of what are you going to do with your whole life going forward, it's kind of one of those things about people leave it till the last minute sometimes, or they don't think about it. They're so busy thinking about the furniture and where they're going to live and those kind of things. They forget some of these other things that are pretty important.
Absolutely.
And so, Ron, let's just jump in. Let's say, what is estate planning?
So, I mean, at its core, estate planning is, a mechanism to make sure that what you own, what you have, goes to the people you want it to go to. And, oftentimes in a way that you want it to get to them, because there's a variety of ways you can leave someone an inheritance. So it's really about just making sure your wishes are fulfilled in terms of who you want to benefit and how you want to benefit them.
Okay. And so let's start off with what is a will and how does that work?
So a will, or a last will and testament, is a device that at its core does just what I said, designs how your estate will be left to the people you want to leave it to. There are some issues with a will, though. It does what it's designed to do, certainly, and identifies who your heirs are and how you want to leave assets to them. But it also raises some issues, which the primary one is probate, right? If I have just a last will and testament, or I have nothing at all, then my estate necessarily has to go through probate upon my death. And that can be kind of a tedious, long process to get through.
Okay, so tell us some of the downsides to having to go through probate. From my experience, it's been time and money.
Time and money are the big ones. So what a probate means, for those of you who have not had to go through one, at its core, it's just a mechanism to get what you own to who it's supposed to go to. But it's a court mechanism. And anytime you're in court, it takes time and money to get through. So even in a simple case, kind of a typical family, they have a house, a couple of cars, some bank accounts, maybe an investment account. That probate process can take about 9 to 15 months to get through. And if your estate is more complicated, if you've got business ownership, for example, or real estate in other states than the state you live in, it can take much longer to do. And especially if you have real estate in multiple states, then you have to do a probate in each state where you own real estate. So it can get very time consuming and expensive in those cases where the assets are a little more complicated. And like I say, it takes long enough in even a simple case. But kind of another downside of doing probate, because it's a court process, it's a public process, which means anyone that wants to know what you own, how much it's worth, who's going to get it, when they're going to get it, that's all public record. Anybody can look that up. So that's kind of a pretty big downside. A lot of people don't want their lives to be part of the public record. But if you have to go through probate, that's what happens.
I don't think I'd want my life to be public record. I agree with that one. So the other thing that I've learned about wills, and possibly with trust too, is that it has to have a personal representative or an executor, or how is that done? Who is that person and what are their responsibilities?
Yeah. So if I have a will, or again, nothing at all, and my estate has to go through probate, the executor, or in Arizona, it's called a personal representative, is the person that's charged with initially opening up this probate estate with the court, gathering my assets, paying all of my last bills that need to get paid. It may be funeral expenses, expenses of last illness, credit card bills, any kind of bills that need to get paid after I'm gone. And then ultimately, once all the bills are paid, distribute the assets to, where my will says they're supposed to go. And if I have no will, then it's according to Arizona law, where my assets are going to go upon my death. And Arizona law is designed to sort of mimic what most people would want, meaning if I have a surviving spouse, the assets will go to my surviving spouse. If I have children and no surviving spouse, it'll go to my kids. So Arizona law, if I have no will, does kind of mimic where they're supposed to go. But let me throw one big caveat out there, which is in second marriage situations, if I die without a will and I have a surviving spouse, but I also have kids that are not the children of my surviving spouse, then my kids get most of my estate, not my surviving spouse. So that can be a real issue. And having a will, of course, does away with that, because I pick who inherits what's left. But being a personal representative is a big job. So you really need to pick someone that is responsible, is good with money management, and is trustworthy, that you trust is going to follow all of the dictates of your will.
Okay, and so what about the assets that are held as joint tenants or pay on death?
Yeah,
or
good question.
Transfer.
So even if I have a will or I have nothing at all, the only assets that have to go through probate are assets that are just in my name upon my death, that do not have a joint owner or a beneficiary or a pay on death beneficiary. So, and that's why in many cases, at least as between spouses who own typically everything jointly, or the spouse is the beneficiary of retirement plans, life insurance, then no probate has to happen when the first spouse dies, because now everything will automatically pass to the surviving joint tenant or the named beneficiary. So a lot of times, there is no need to probate an estate when the first spouse dies. But if that first spouse to die has an asset that is just in their name, then a probate may need to be opened just for that asset. And sort of the problem with probate is it doesn't really matter if you're putting one asset through probate or 20 assets through probate, the process is the same. So the time is the same to get through that probate, whether it's one asset or 20 assets. But
I've also heard that it takes a lawyer to help get you through probate. So is that true or not true?
I think it would be very difficult to get through a probate without having legal representation. There's just an awful lot to it. And it's sort of that you don't know what you don't know.
Right.
And there's all kinds of steps that have to be gone through, specific time frames and time limits that have to be met. And you're just not going to know that trying to do a probate on your own.
So hence that drives up the expense of getting just a will through probate.
Definitely. Yeah, definitely. Yeah, it's
Okay,
really
so
a do-it-yourself thing.
that's why we have you. So Ron, to explain to us the difference between a trust and how is it different than a will?
So I think there's some very important distinctions between a trust and a will. So a trust, at least the kind of trust we're talking about, which is, called a living trust or a revocable trust. And all that really means is, just like your will, once you put it in place, you can change it at any point in the future. There's nothing written in stone with a revocable trust or a living trust. That kind of a trust is just an agreement you create with yourself. Say, I'm going to create this agreement, and then I'm going to move everything I own into the name of my trust. So instead of my bank accounts, for example, being in Ron Adams' name, right, they'd be in the name of the Adams Living Trust. And everything I own, except for one really important exception, which is the ownership of retirement plans and IRAs, and I can talk a little bit more about that. But really, everything else I own, I want to move into the name of the trust. Because remember, the only assets I have to put through probate are assets that are just in my name when I die. Well, with a trust, there is nothing in my name when I die, right? It's all in the name of my trust. Now, while I'm alive, that's okay, because I control everything that the trust owns, right? A trust has three parties to it. There's the creator of the trust, which is often called the grantor or the settlor. There's the trustees who control what the trust owns for the benefit of the beneficiaries of the trust. Well, while I'm alive, I'm all three of those things. I created the trust, I'm the trustee, I control the assets as the trustee for my benefit as the beneficiary. So one big advantage of a trust over a will is if I do it right and I move all my assets into the name of the trust, I don't have to go through probate at my death. So I avoid probate. And that's the big advantage of a trust over a will. But another, I think, big advantage is dealing with the issue of incapacity. We're living longer, but we're also seeing higher levels of people developing cognitive problems because of living longer. Well, if I have just a last will and testament, that only talks about what happens when I die. There's nothing about a will that addresses what happens if I'm alive, but I become incapacitated. And in a minute, we can talk a little bit more about how I deal with incapacity if all I have is a will. But in a trust, I can deal with it very specifically. I can, for example, define within the trust how it's determined if I am incapacitated. But better, I've already developed a mechanism within the trust for a successor trustee to step into my shoes if I am incapacitated. So there's no court involvement. And it's easy, if I am incapacitated, for the person I've named to just step into my shoes and as trustee now take over management of all of the assets and to be able to use those assets for my benefit. Also, if there's other people that I'm taking care of, maybe a parent that is in assisted living or a nursing home, or is living on their own but needs help, or adult children that may need financial help from time to time. With my trust, I can designate to that successor trustee that trustee, as long as I'm taken care of in my incapacity, you also have the ability and the authority to help these other people that I've identified if they need financial help in an emergency. So a trust is really a lifetime instrument. Like a will, it does address what happens when I die and who inherits what and how, but it also deals with lifetime issues like this incapacity planning that I just can't do in a will.
Okay, so you brought up another thing then, you keep saying trustee. So who should be the trustee and what does their job actually entail?
Yeah, I mean, great question. the trustee is sort of like the personal representative under a will. So it's a person that is entrusted with the management of my assets, either upon my death or upon my incapacity. Because remember, while I'm alive and not incapacitated, I'm the trustee, or me and my wife are the trustees, right? And the trust is really no different than we are while we're alive. Meaning, the only real difference that I would see day to day is that assets are in the name of my trust and not in our individual names. But nothing really else changes day to day. We still control everything. It's all for our benefit. With a living trust, there is no separate tax identification number for the trust. There is no separate tax return to file. It's still just us, right? Me and my wife. There's really no difference. But if we become incapacitated or upon our death, then we need to name who's going to take over for us. And if it's an incapacity issue, who's going to take care of us in our incapacity? So the trustee's job is a little bit different depending on whether they take over because of incapacity or because of my death. If it's because of my incapacity, then their job is to, figure out living arrangements for me, how to pay for those arrangements out of my assets, pay my bills, basically take care of me as if they were me.
So they would have access to all of these assets, for example, your bank account, so that they could pay these expenses and they could sell the car, or they could do whatever they needed to do for you if you're incapacitated.
Exactly, right. So they would step into my shoes, and because my assets are in a trust, they would automatically have access to these assets, where if all I had was a will, then they don't have access to those assets without using what's called a power of attorney. And we can get to that in a minute, because there's some pitfalls with trying to use a power of attorney if all I have is a will. So in a trust, I don't have to be concerned that they're going to be delayed in getting access to my assets to take care of me and pay my bills, because as trustee, they'll just step right into my shoes. But, again, it's got to be someone I trust. It's got to be someone who's going to follow the directions I've put in the trust. I mean, oftentimes, we'll name adult children as our next successor trustees. And in most cases, that will work fine. Sometimes people they either don't have children to be able to step into that role, or they have children that for whatever reason, they can't trust to step into that role. And there are companies, private licensed fiduciaries, that you can name and hire to step into those roles that, will charge a fee to do it. But at least there's an independent third party that I can hire to do that for me.
Well, that's really relevant. I've forgotten about that. If the child or who's ever, quote, inheriting is not really capable of managing it.
Right.
And there are families that are like that.
Definitely.
So,
definitely. And more than you would think. So
I'm starting to learn that. Okay. So upon your death, then what is the trustee's job then?
Then it becomes more similar to the personal representative, which is their job is to step in. And again, it'll be easier for them to do that because my assets are owned by the trust. But to step in, collect my assets, pay whatever bills need to get paid at the time, and then ultimately distribute those assets as to how I've designed it in my trust. And as I mentioned earlier, there's lots of ways to leave someone an inheritance. So, one way, and this is especially easier to do in a trust, although I could do it in a will, but it makes it very complicated for my will. But one way I can do that in a trust is to just say, once I'm gone, all my bills are paid, the trustee can then just give, the people that I've identified their share of the assets. Right? So let's say I have 3 adult children, and I tell my trustee upon my death, just split the assets 3 ways among my kids. Well, one way I could set that up is you just give it to them, right? Another way I could do that, though, is to continue to hold and tell the trustee, continue to hold their share of the inheritance in a trust for them. The advantage of doing that is that even if I then allow the adult child to become their own trustee of their own share, so they control their own inheritance, they can decide how to invest it, how to spend it, when to spend it. But as long as it stays inside that trust that they now control, no one else can get to it. If they got sued, if they caused a car accident, if they got into a bad marriage, right? If they racked up a bunch of medical bills, whatever happens in their life, at least the inheritance is protected in that trust for them. They can continue to use it and benefit by it, but nobody else can get to it. So we tend to do quite a bit of those, actually. And of course, if I have a child who has issues, they've got an alcohol issue or a drug issue or are just horrible with money, and I want to make sure that the inheritance is going to last for them, then I can name somebody else as the trustee over their share, and allow only the kids that I know are going to, manage it well, become their own trustees. So there's just lots of different ways I can work with a trust and the inheritance that I might want to leave people that is much more difficult to do under a will.
Okay, and so I wanted to go back to the topic 2 of incapacitation, and then I also wanted to talk to you about end of life. Oh wait, I'm not to that part. I see. Okay, let's go there. End of life directives and incapacitation, because you taught me a lot. We made some, they're minor changes, but significant changes based on your advice the last time Rick and I met with you.
Right. Well, let's kind of circle back to the incapacity issue and what I can do if all I have is a will, or what I need to do if all I have is a will. Because I think this is a very critical distinction between a trust and a will. So remember, if all I have is a last will and testament, all it talks about is what happens when I die. So the thing that we use to deal with what happens if I become incapacitated is called a general durable power of attorney. So it's an instrument that says, if I become incapacitated, here is the person or the people, it could be more than one person, who take over for me. And basically, they could do whatever I can do with my assets, personally for me. Anything I can do, they can take over and do for me as a result of my incapacity. There's a few issues that come up with using a general power of attorney. And let me make one clarification. All the durable part of the name of a general power of attorney means is that the power of attorney itself is not affected by my later incapacity or disability. That really only becomes important in this sense. I can make a power of attorney effective only upon my incapacity or immediately upon my signing it. Well, if I make it effective immediately upon my signing it, I don't want it to be revoked by my later incapacity or disability. So that's what the durable part of it means. But for the most part, we will make powers of attorney effective only if I become incapacitated, because they are can be a very dangerous instrument, as you can imagine. If I name someone and give them the power immediately to take over my assets, sell my house, get on my bank accounts, I better really, really trust the person that I've named to do that, because they can then do whatever I could do with my assets. But if I am incapacitated, I'm really going to need somebody to take over for me. So the potential downfalls of using a power of attorney like that. One, as I mentioned, it typically is going to say it's effective only upon my incapacity. How incapacity is defined, though, is almost invariably I'm incapacitated if a doctor writes a letter that says I am. Now, if I've got a diagnosed issue, I've got Alzheimer's, early stage dementia, I've got cognitive issues, my family and I are already working with a neurologist, they can probably get him or her to write a letter that says, Ron should no longer be managing his own affairs for these reasons. But if that's not the case, it can be a trial to try for my family to try to find a doctor who will do this competency evaluation and make a judgment as to whether I'm competent or not. So it can take time to even get past this. It's effective when I'm incapacitated, and I'm incapacitated if a doctor says so issue. But assuming my family gets past that hurdle, the second issue with a power of attorney is the law says I can put one in place, but there's nothing that requires a third party, like a bank or a brokerage house or a title company, to accept or honor a power of attorney. It's completely up to that third party whether they take it or not. Now, most of the time, it's not an issue, but every once in a while, you'll run across a bank or a brokerage house that just won't take it. It's too old. They just don't like the form it's on. For whatever reason or no reason, they just won't accept it. Well, now my family's stuck, right? Their only option at that point is to go to court, file a petition for a guardian and conservator to be appointed over me, and then have this long drawn out court process to be able to get access to my assets. Well, the power of attorney is designed to avoid that, but it's not guaranteed because there's no requirement that third parties accept it. Well, with a trust, I don't have to worry about any of that because I've defined in my trust how it's determined whether I'm incapacitated. And because of this issue with requiring a doctor certification of competency, many, many years ago, in our trust planning at least, we went to this private determination where I pick the people that determine whether I'm competent or not. So in my case, for example, I have my wife, my brother, and my son, adult son, it has to be an adult, but they can declare me incapacitated by a majority vote. Although in my case, I've said my spouse has to be part of that majority. But if they may take that vote and decide I'm incapacitated, and it's not a legal determination I'm incapacitated, but for purposes of my trust, I'm no longer a trustee. Now my wife continues as the only trustee. So it's a much quicker, easier, streamlined process for my family to make that determination. And now my successor trustee can step right into my shoes and control the trust assets.
And no one knows you better than your own family,
Exactly.
usually.
Yeah, exactly. And oftentimes people will even pick close friends to help make that determination. It just needs to be people that interact with you enough to know, look, something's going on with Ron. We probably ought to get together and talk about it and see if there's anything we need to do. But again, it's just a much more streamlined process. And
I also liked when you talked with me and Rick about it, Rick was really quick to say, oh, well, Carol will make that decision. And I said, I don't know that I want that full responsibility. And it's not because I'm afraid to make a decision, because I'm certainly not. But when you're distraught and you're worried, it really does help to have that, like you put in a team of 3.
right.
So you don't have 1 or 2 that have to agree, but you could have 3. And so then you just have to have 2 of the 3 agree.
Right. Or more, I
Right.
could add 4 or 5 maybe. I mean, the more people I get involved in that process, the little more cumbersome it becomes.
Right.
But I'm not limited to how many people I want on that panel. But the other thing I like about that is if the spouse wants to step back from the decision, being part of that panel that makes the decision of competency, if there are other panel members, then he or she can do that and step back from the decision itself. Because remember, if I'm declared incompetent by my family, I might not be the happiest that that was done. And if my spouse has the opportunity to step back from it, she can say, look, it wasn't me. It was your brother and your son that made that decision. Now, I agree with them. You probably shouldn't be driving and you shouldn't be managing things. But really, it was up to them, and that's what you agreed to.
Okay, so you want to talk a little bit about a revocable versus an irrevocable trust?
Sure. So, as I mentioned early on, a revocable trust just means I can change it at any point in time in the future. There's nothing written in stone about it. An irrevocable trust means that once I create it and put it in place, I can never change it again. Right? It's going to say what it says. And if I'm not happy about what it says 10 years from now or 20 years from now, I don't have the ability to change it. So a revocable trust or revocable trust is really put in place for estate planning purposes, making it easy on whoever comes after me to be able to take over and manage things and ultimately distribute my assets to who they're supposed to go to. An irrevocable trust is typically more done for either estate tax planning purposes or for liability, asset, and creditor protection purposes. So if I create an irrevocable trust, really one of the purposes I might do that is to move assets out of my estate for tax purposes, so that upon my death, those assets are not part of my estate for estate tax purposes. But the reason they're not is I've essentially given them away. Right? I've created an irrevocable trust that benefits my children, grandchildren, maybe other descendants, but I can't use those assets anymore, at least for my benefit. I can only use it for their benefit. And that's why, because I can't use them for my benefit anymore, they're not part of my estate for tax purposes. Now, in today's world, most people don't have to worry about estate taxes, because I can leave up to $11.7 million to anyone estate tax free. So together, my spouse and I can leave, over $23 million estate tax free. Now, with that said, with the incoming Biden administration, there are proposals being floated to change the estate tax and lower the amount I can leave estate tax free. And what they've been looking at is to leave the maximum at about $3.5 million. But even then, together, my spouse and I could leave up to $7 million estate tax free. So it's still not going to affect the majority of people. But that's one reason I may create an irrevocable trust, is if I do have an estate tax problem, to move those out of my estate for tax purposes. And as an aside, I also get creditor protection in those assets. So if I get sued, or even if my children get sued, those assets can't be touched anymore. They can be used for the benefit of my children and grandchildren, but can't be taken by a creditor, either my creditor or their creditor. So there's some added benefits to that. But again, to get that protection, I've got to give those assets away. So if I need them to live on, if I need them to pay my bills, I can't give them away like that and get any kind of creditor protection.
Okay, and so what are gift taxes and how does that work?
Yeah, it's a good question. So gift taxes are, just as there's a tax on my ability to leave assets at my death to my heirs, right? This estate tax. There's also a tax on my ability to give assets to my heirs during my lifetime, or to give them to anybody. It doesn't have to be my children or grandchildren. Currently, I have the same gift tax exemption as I do estate tax exemption, which means I can give up to, $11.7 million during my life and not pay a gift tax. However, every dollar of gift tax I use during my life, I lose a dollar of estate tax at my death. So if I give away $11.7 million of assets while I'm alive and use up my gift tax exemption, at death, I will have no estate tax exemption remaining. So every asset I still own at my death is going to be taxed. Now, I can give any individual up to $15,000 per year in cash or assets without triggering a gift tax. And my wife and I can join and give up to $30,000. So I could give to each child of mine, for example, up to $30,000 a year if my wife joins in the gift without having to report it, without triggering a gift tax. If I give more than $15,000, so let's say I gave a child $100,000 to help him start a business. Well, $15,000 of that is covered by what's the annual exclusion, which is this $15,000 limit. So if my wife and I joined, we could, 30,000 of it would be covered by the annual exclusion, but the remaining 70,000 would be subject to the gift tax. So the year following the year I made the gift, I would have to file a gift tax return, which is a IRS form 709. And I would show that my wife and I were using up $70,000 of our $11.7 million gift tax and estate tax exemption. Now, so, again, I could give away an awful lot during life. I just keep reducing the amount I can leave at death.
Okay, that's pretty cool. And I didn't know that. So that was a real lesson there.
Quick item, which is under the proposals that would drop the estate tax exemption down to 3.5 million. The proposal is to drop the gift tax exemption down to 1 million. So we could see some pretty big changes in the gift and estate tax laws in the future.
Okay, well, we'll just have to see what happens. All right, so what's a general durable power of attorney? Or did we already cover that?
We touched on that. What we haven't really talked much about yet are the medical side of things. Gotcha. And how to deal with medical decision-making. Do I want to be kept alive artificially? Part of an estate plan. So, whether I create a will or a trust, the will, the trust, the general power of attorney, those are all things that primarily deal with finances, right? The medical directives are the piece that deal with what happens if I can't make my own medical decisions. So in our office, at least, there's 3 parts to the medical directives. There's a healthcare power of attorney, and we'll often combine that with a mental health care power of attorney. There's a living will, and then what we have is a HIPAA authorization. So the healthcare power of attorney is what it sounds like. It's kind of like the general power of attorney, but it's limited to medical decision-making. It says if I cannot make my own medical decisions for whatever reason, then this is the person or the people that make those decisions for me. Now it will tell them, look, make decisions based on what you think I would want to have happen. But ultimately, if I'm incapable of making my own medical decisions, it's up to you, my agent under my healthcare power of attorney. The living will is then the piece that directs my healthcare agent as to whether I want to be kept alive artificially or not. So typically it will say, if I'm in a persistent vegetative state, I'm brain dead, or I'm in an irreversible coma, or I have a terminal condition that I otherwise am going to die from, but for this artificial life support that's keeping me alive, then pull the life support. Keep me as pain-free and as comfortable as possible, but do not do anything to just prolong the natural dying process. Now, to get there, both my attending physician and another independent physician have to be telling my agent, look, there's just no chance from a medical perspective that Ron is going to come out of the situation he's in. So, you agent, it's time to implement their wish to end their life naturally and not be kept alive artificially. So, you may remember this situation with Terri Schiavo out of Florida. It's been a number of years now, but she was brain dead. And her ex-husband and her parents were fighting over whether she would have wanted to be kept alive in that condition because she did not have a living will. And, it got ridiculous enough that Congress was arguing about what she would have wanted. A living will avoids that, right? It lets me direct what's going to happen at the end of my life. So really important document to have. And then the last piece, this HIPAA authorization, just tells the medical community, these are the people that I've identified that you can talk with about my otherwise confidential medical information. So again, important to have so that those people that I've identified that are involved in making the decisions for me medically can get the information they need to do that. So those three pieces, are the medical directives. And one thing I want to point out, the healthcare power of attorney is not a do not resuscitate order. So it's not saying, if I have a heart attack, don't try to revive me, right? It's a true end of life. I'm going to die anyway, but for this artificial life support, then pull the life support. There may be a point if I'm in hospice care where I want to do not resuscitate order, but that's not what the living will is. It's a true end of life, artificially being kept alive. Let me go now.
Okay. So that's what the medical directives are, those three pieces. And I was really surprised when I was doing the research for my book that even if you have the power of attorney, if you don't have that HIPAA, then a lot of times you're still, you are precluded from doing your duties.
Right.
If you don't have that with all three of those things, or at least those two for sure.
Medical providers are understandably very careful with protected medical information. Mm-hmm. They face huge penalties if they violate the HIPAA laws. Now, I like to work in kind of a redundancy. So my healthcare power of attorney also names the agents that I've identified to make healthcare decisions as authorized HIPAA representatives.
Right.
And then we have a separate HIPAA authorization just as a backstop. So it's very, very clear the medical community can talk to these people. Because otherwise, you're right, they could be in a real conundrum if they're supposed to be making decisions but can't get access to my medical information.
Right, and I've seen that actually happen, which is why I thought I'd bring that up. We pretty much covered all the topics that I think you and I had discussed that would be of importance. Sylvia, welcome to the show today. Did you have any questions for Ron or Rick? Did you?
Okay. Yeah, well, it was all very good. And I know through kind of hard experience, some of that stuff. And, but I've always thought that you only needed a trust when you had a lot of assets. Is that true or not?
I don't think so. It depends a little bit on what the assets are, but the primary purpose of a trust and kind of this myth of thinking I need a lot of assets before I need a trust really goes to this estate tax issue, because there's been a number of changes to the estate tax laws, and there was certainly a time pre-2009 where having a trust could save me on some estate tax issues, even with a fairly modest estate. Now, that's not so much the case now with how high the exemption is that I can leave estate tax free. But I think this idea of I need a lot of assets before I need a trust kind of comes from that thinking of dealing with estate tax issues. But really, I think the purpose of a trust is to make it as easy as possible on the people that come after me to be able to do things, right? Without having to go through a probate, because another issue that I didn't really mention earlier with probates is opening up a probate estate makes it easier to fight about things if there's going to be a fight about things, because there's already this court proceeding in place. So if somebody wants to fight about the way I did things or how I left things, they can just step right into that probate. They don't have to go out and try to find a lawyer to file a separate lawsuit. They just step right into this probate case and can deal with it there. So I think a trust makes sense to do if I want to make it as easy as possible on the people that come after me. Having a living trust is kind of like doing a living probate, meaning somebody has to do that work at some point in time. That work being collecting my assets and moving them over to where they're supposed to go. Well, if I just have a will or nothing at all, the people that come after me have to do that work. They have to open up this probate, collect my assets, ultimately get them to where they're supposed to go. But if I have a trust, I've done that work while I'm alive. I've moved everything over into the name of my trust. And now my trustee, who I've named to come after me, just steps into my shoes and can control everything. So it's just much easier on them. And also this distinction of how I can deal with incapacity planning is just much better in a trust than a will. But when I say it kind of depends on what assets I own, let's say that the vast majority of what I own is in a retirement plan or an IRA. Well, a trust isn't really going to help me with that asset, so, and there's reasons for that, but if that's not the case, then my trust can really control everything else I own. And like I said, it just makes it a lot easier on those who come behind me.
So you'd always have a will and a trust. They work together.
You do, but when you have a trust, the will is a very different kind of will. It's what's called a pour-over will. So if I don't have a trust, my will has to say, okay, here's where things go upon my death. Here's who inherits. Here's how they inherit. But if I have a trust, my trust says all of that. So the purpose of my will when I have a trust is just to get assets that are not in my trust while I'm alive into my trust after I die.
Oh.
So the only beneficiary of my will when I have a trust is my trust. So it just says executor, personal representative of my estate. I have this trust and I sure meant to put everything I owned into it while I was alive. But if I missed anything, your only job is to put it into my trust after I'm gone. Oh, there is a will, but it's a much simpler will. Now, I don't ever want to have to use that will, because if I have to use a will, I still have to do a probate. But it's there as a backup, just in case I missed anything while I was alive.
That was a good question.
Yeah.
Well, okay, but so just to clarify that,
Sure.
you were saying, is the will like a pour over will into your trust in case I missed anything? But if that happens, does that will have to go to probate then?
It does.
Oh, okay.
It does. And that's the problem. As I mentioned on, it's because a probate process is the same, whether I'm probating one asset or 20 assets, I've still got to go through that process, even if it's just this one bank account, for example, that I left in my individual name.
Mm.
If I have to open up a probate to get that
Mm.
bank account over into my trust, I've got to go through that same probate process.
Hmm.
Now, that doesn't mean, there's certain limits to probate, meaning if the personal property that I own at death is worth less than $75,000, there's a mechanism I can use to get to that asset without doing a probate. So if I left a single bank account, for example, out of my trust, and it had less than $75,000 in it, then there's a way I could still get to it without doing a probate. But if it's a piece of real estate that I left out, or a brokerage account that has more than $75,000 in it, well, now I've got to open a probate just for that one asset.
Mm. Well, I mean, can you have a trust without a will?
You could, but here's the thing that could happen is, let's say I created a trust, and the trust describes how I want things to go upon my death. And I've left this brokerage account, investment account, out of my trust. It's still just in my name when I die. If I don't have a will that says, okay, personal representative, your job is to move that over to my trust,
Okay.
then I've died in what's called an intestate capacity,
Oh,
which means Arizona law dictates who gets that account.
I
My
see.
trust does not.
okay.
So I could do that, but it's pretty risky.
So basically, you avoid probate if you have a will, but everything's already in your trust. And
Well-
then you completely avoid probate that way.
Yes, yes. So let me make that really clear. I did mention that if I have a will, it necessarily means my estate has to go through probate. That is not the case if I have a will in connection with my trust.
Okay.
And I've made sure everything I own is in the name of my trust.
Okay.
So yeah, I can see where there would be some confusion there.
Mhm. Okay, good.
Yeah, if I have a will with my trust, my estate does not have to go through probate as long as my trust owns everything.
Okay.
That could make a really big difference to the survivors. So from the real estate standpoint, if the person passes and, well, I should say when, because we're all going to be there. But then the trustee, if they're the trustee of the trust, they are able to sell that property and in a timely fashion, which could make a big difference to whatever is happening to the other people as well. Maybe they need that to pay off more medical expenses or whatever, but the timeliness of being able to do that is a huge differential. And even if the house is paid off, if you think about that, they still would need to be paying electric and lawn care and insurance for X number of months until that asset is sold or transferred to another heir.
Right.
That's a pretty big chunk of money and a big chunk of time. So that's a real valuable thing that I've seen come through our offices.
Well, and that's just part of what I mean, where a trust just makes it so much easier on the people that need to step up and do things after I'm gone, right? Because they control everything almost immediately and are able to do the things they need to do.
I'm sorry, I had somebody coming to my house right now. I'm going to have to leave, but
Oh,
thank you so much. It's been very, very interesting. I really appreciate being on this today.
Sylvia, thank you for joining
you.
us.
And we'll talk again.
Okay, and so Ron, I want to thank you for being on our program today and
Oh,
sharing
sure.
your wisdom. And we really appreciate your time. And to our audience today and future audiences, we look forward to helping to educate and equip you to make powerful, informed decisions.
Great.
Everyone have a great day.
Thanks, Carol. It's great seeing you.
Thanks, Ron. Good to see you.
All righty. Bye-bye.
Bye-bye.